Welcome to the June 28th, 2022 Zoning Board of Appeals meeting for the town of Raymond. The Zoning Board of Appeals will come to order. The board does have a quorum. I'm now going to do a roll call. Let's start with myself first. David Murch.
Greg Dean.
Tom Hennisley.
Fred Mella. This is a public proceeding, and unless the board specifically votes to go into executive session, you have the right to hear everything that is being said and to look at all of the exhibits that are presented. Please notify the chair if you're unable to see or hear. The board works from a published agenda and will be considering tonight's items in the following order. Number one, call to order. Number two, approval of minutes of the May 17, 2022 special meeting and the May 31st, 2022 meeting. Old business. Administrative appeal, notice of violation issued 12/16/2021. Applicant Leah B. Rashina Esquire on behalf of Management Controls for 18 Fernwood Road. Second item, administrative appeal, notice of violation issued 1/4/2022. Applicant Leah B. Rashina Esquire on behalf of Q Team Inc., location 18 Fernwood Road. Number three, administrative appeal, notice of violation issued 1/28/2022. Applicant Leah B. Rashina Esquire on behalf of Management Controls LLC, location 28 Whitetail Lane. Number four, administrative appeal, notice of violation issued 12/28/2021. Applicant Durant Excavating, location 18 Fernwood Road. An administrative appeal, notice of violation issued 1/28/2022. Applicant Durant Excavating, location 28 Whitetail Lane. Public hearing, applicant Eric Coleman Furnish, location 90 Tenny Hill Road. Public hearing, applicant Deborah Haas Wilson, location 184 Deep Cove Road. Administrative appeal, notice of violation issued 3/10/2022. Applicant Gregory P. Braun Esquire on behalf of Big Lake Marine LLC, Robert Durant, location 18 Fernwood Road. Administrative appeal, notice of violation issued 3/10/2022. Applicant Gregory P. Braun Esquire on behalf of Big Lake Marine LLC, Robert Durant, location 28 Whitetail Lane. And we have new business, public hearing, applicant Fred Hollister, location 67 Wild Acres Road. Then we have code enforcement officer communications, and then finally adjournment. In each instance, the burden is upon the applicant to demonstrate compliance with the provisions of the applicable ordinances or state law. After the board votes on the merits of each application, it will prepare a written notice of decision, because the notice of decision may substantially affect any appeals rights. And also, as a matter of courtesy, the board asks that those attending the meeting with regards to a specific application not leave until the board has completed its discussion. Generally speaking, appeals from adverse decisions must be filed with the Superior Court as otherwise provided by law within 45 days of this board's decision. Also, to be certain that you preserve your individual right to file any such appeal, you must be certain that the board's record evidences your appearance this evening in opposition and the basis for your opposition. All persons speaking, including representatives of the applicant and members of the public, are asked to state their name, their address, and their affiliation with the application, being either for, opposed, or neutral. All persons speaking shall address all remarks or questions to the chairman. And finally, this meeting is not over until the board has formally adjourned. Any discussion not included on the meeting agenda or accepted by the board is to be held until after adjournment or conducted outside of the meeting room. So first up is approval of minutes of the May 17, 2022 special meeting and the May 31st, 2022 meeting. I did notice one item that I think needs to be changed. It's for the May 31st, 2022 meetings. It's on the last page, and it's well, specifically says the board addressed the application filed by Deborah Haas Wilson. Murch stated that a site walk was conducted with the full board in attendance. No representative of the applicant nor anyone else attended. That last part, Sandy, where it says nor anyone else attended. There were some members of the public there. So that I probably stated it incorrectly, but there were no representatives for the applicant. But
And you want me just to stop it there?
yeah, that would
Sure.
be, yeah.
I can fix that for you, of course.
All right. Does anybody else have anything to add? Any of the board members? No. Okay, so I will make a motion to accept the minutes of the May 17th, 2022 special meeting as written and the May 31st, 2022 meeting as modified to indicate no representatives of the applicant were at the site walk. Do I have a second on that?
I'll second.
All right, and I will take 1 second. I see Pete, you are here. Is that Pete Lockwood?
Yes, Dave, I'm here.
Okay, Pete, why don't you go ahead and just officially announce yourself to the public here?
Sure. My name is Pete Lockwood, and I have just joined the Zoning Board of Appeals. This is my first official meeting.
Wonderful, thanks, Pete. So I'll go ahead, we'll have to do a roll call vote since this is a Zoom meeting, so all in favor of approving the minutes. David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Camilla, yes.
Pete Lockwood, yes.
Okay, so that's done. Old business. So we have a number of administrative appeals specific to locations of 18 Fernwood Road, as well as 28 Whitetail Lane. We have received an email from Gregory Braun dated June 22nd, and it says Sandy Durant Excavating and Rob Durant would request that this matter remain tabled and that the hearing scheduled for the June 28, 2022 be pushed out. We continue to seek compromise with the town and would appreciate additional opportunity to do so. And one over here. Then from Leah Rachin, Sandy, this will confirm we wish these matters to remain tabled. This is an email dated June 23rd. The parties are still engaged in settlement discussions and pursuant to our agreement, we have put this matter on hold until July 13th in order to allow the process to work its way through. Accordingly, we ask that the pending approvals be tabled until the July meeting. It's my understanding Attorney Wyckoff is in agreement. However, I'm sure he'll weigh in separately. Sandy, did we get any feedback from Attorney Wyckoff?
Yes, he agreed.
Okay, and I see Alex is on the call, not shown, but
There
Alex,
he
are you
is.
in agreement with tabling these as well?
Yep, I am in agreement.
Okay, so board, given that all parties involved would like to, are requesting that we continue to keep these notices of violation tabled for 18 Fernwood Road and 28 Whitetail Lane.
Hey, David, this is Tom.
Yeah, Tom.
Can I just, I guess, we've tabled these things multiple times already.
Yep.
So without any progress report from any lawyer or Alex, from what I know, I'm reluctant to table it again, but I think we need to establish a drop dead line that says no further tabling after July 13. And I'll leave it open for Alex or anyone else to comment.
Yeah, I mean, I don't, oh, sorry, Greg, go ahead.
No, go ahead.
I don't really think I can say anything else, or else I would. I would say that, you know, the applicant has the ability to, I suppose, withdraw their appeal. If you guys wanted to do that, I think realistically you could. But I think the only reason we're tabling at this point is because I think both sides are hopeful that the talks will continue to be productive, and then we won't have to waste anyone's time going through the appeal process, because as you saw with the last one, it's a very lengthy process, and it gets very expensive very quick. So that's the only reason I think you may find that things change soon, but I don't really know for sure, so I can't say anything else, I guess.
All right, so Alex, in the meantime, the town and the other attorneys involved, they're all billing their customers and with no payment going to anyone, right?
Correct.
Is there any way to seek partial payment for the town for what has been incurred to date?
I don't think so without going to court. Or the other side coming to some type of agreement, I guess, you know, a consent agreement of some type.
A quick comment.
Sure.
Yeah, I think in spirit agree with, I think, Tom's frustration. I think it's, I would also add that the board meets and we have several times and we have to kind of roughly figure out how much of a time commitment we're going to set aside in advance. And it's, we're looking at, it's also a little bit, unjust to, if this doesn't, the second this doesn't get tabled in your new business, I mean, you're looking at a pretty big backlog. I think that maybe not a drop deadline, but I think personally, I'd like to just say on record that the second that it's not a mutual thing, and one or at least one party doesn't want to table it, I think that we're going to not table it. At least that's what I would encourage if we did get to that point in time. So I think I really hope that there can be a resolution outside of, if both parties are working towards that. But as soon as it's not both parties, I think that we need to start working through it. That's kind of my thought.
So I will say that, from our end of things, that we have made it clear to all parties involved that there's, just because they request an item to be tabled, it doesn't mean that we will. So they all understand that we could address all of these issues tonight if we so chose. So.
And it's, sorry, just to clarify, tonight, it also could be in a special meeting with enough advance notice, correct?
That's my understanding, yeah, if we schedule something and let them know.
Okay, that is an option, I think, that we should not take off the table.
And in the meantime, nothing is being done at the site itself, Alex, right?
There's currently a pending permit for the demolition of the hot tub, which I believe is supposed to happen pretty quick here as soon as the permit's issued, which will hopefully be Friday, I believe.
Okay. And
other than that, though, to answer your question, no other activity.
Okay. And do all the other board members know how visible this thing is now in the politicians' realm?
I am not aware, no. No.
Do you want to fill them in, Alex, or me?
I can speak to it if you want. We did have a boat ride. Oh God, I don't even know. It was probably a month or so at this point. Month or so ago, we took out our state reps and we basically showed them the property from the water. I think we had about 15 people total. We took out. We had some people on a boat that took the code officer, my assistant code officer, myself, and one of the state reps, and then the other boat had 10 people on it. So the fireboat. So we went out and took a look at the property from the water. And the whole point was to, just make sure that they were aware. We had noticed the end of May, we were starting to get a lot more calls on this property just because the work was done in October and a lot of the summer residents had already left for the season. And now that they've returned, they're out on their boat and they're seeing it and they're saying, oh my God, what happened? What's this? Let's call the town. So, sometimes what happens is these people will call the state directly. They'll call DP. They'll call, Portland Water District, LEA, or they'll call their state representatives. So we went and, basically got all of them together. Portland Water District, the director from Lakes Environmental was there. We took them all out and said, this is what happened. We want to make sure you're all aware of it. And that way, if someone calls you, you'll know what they're talking about. And I think it was a good day. I think they were all able to kind of get a lot of information, get everyone together on the same page. So that's, I think Jessica Fay may have posted something on Facebook, which I think is where a lot of people saw that there was the boat tour. And I think Bridgeton News actually ran a story on it too a couple of weeks ago. So it's out there.
Can I ask a question, Dave?
Yeah, of course.
So our attorney's involved with the other attorneys, correct? I mean, they are working together.
I mean, our attorney just speaks on our behalf, so he's not working in regards to any of the talks that are happening between the town and the parties involved. Our attorney is separate from all of that.
No, but I'm talking about the town attorney.
Oh, sorry, town attorney.
Sorry, the town attorney. Yeah, sorry, I didn't specify that. And he's the one that said it, that he was willing to be tabled. This is correct? And it wasn't our attorney. We're talking about the town attorney, right?
All
Yes.
attorneys involved have requested that it continue to stay tabled.
Okay. So I guess my thought onto that is that there must be some kind of something happening behind the scenes that we don't know about. Because if that lawyer for the town is willing to continue to want to extend this, then they must be making some kind of headway that they feel that they're going to make some kind of a decision soon, instead of just, you know, saying that, you know, we've come to an end and don't seem to be going anywhere. That's just a thought and a question.
One of the things that I guess I can say is they did submit an after the fact permit to DEP. And I believe they also submitted to Army Corps as well. That happened, I want to say probably 3 weeks or so ago. So that process is moving, that after the fact permit process is moving. And I did also hear that they've hired a new environmental consulting firm that specializes in remediation projects. I think they do more industrial commercial stuff, but they also do some residential. So that person's been hired. We haven't had, as far as I know, we haven't had any conversations, you know, myself or the attorney with this new company yet, but, you know, that's, so there's stuff that's happening. And the time frame to table was established at our initial mediation. So it was something that was kind of worked out during mediation, that we would essentially freeze everything to allow time to work on the remediation plan, which is kind of the, you know, the big sticking point right now. That time is, I think, quickly running out. So without saying much more, I think this situation will probably unfold soon for you guys. But one thing we could do, if you want, let's say it gets tabled again, or there's a request to table again from both sides. I could probably have the town's attorney attend the next meeting if you guys want to get more of an update from him. I just don't know, you know, since this is kind of above me at this point, I don't know how much I can say without it, you know, being a problem.
Yeah, thank you, Alex. I'll leave it to the board to, you know, talk out loud about that. The only thing I have the same frustrations as Tom and as Greg, but I will say what I don't want to do is impede any progress that's currently happening, or to put something in place that will, you know, I'd rather us be ready for when this comes to us than us to do anything that brings it to us a little bit too quickly. But I do appreciate Tom's comments about sort of getting some feedback as to where things stand, because it is kind of hard each month coming to these meetings, not really knowing what to expect, as well as the public. Tom's right. You've got people who have new items coming on, and you know, those can get really pushed way back depending on what's going on. So it would be nice to have some sort of insight as to what's going on, especially considering these have been tabled for a while now. So.
Alex, is the fear of a public meeting with the town's attorney, or does this need to be an executive session or a special meeting of some sort?
I don't know that you could do an executive session because myself and the town's attorney were one side of the argument. I think you could do you could do an executive session with Stephen Wagner if you wanted, who is, you know, the board's representation. And I mean, it might be something that if you guys, you know, in the next month or so, if David wants, maybe he could reach out to him and, you know, see if that might be appropriate at this point. But I think if Eric is to come in and give an update from the town side, I think that you'll find all the other attorneys are going to show up as well. And they may want to also provide an update from their side. It could get interesting. So that's kind of why I think they're all agreeing to not, because when they say that they're in agreement with tabling, they're essentially saying we're not showing up, we're not preparing for this meeting. We're not spending any time to prepare for this meeting. We will not be there. And they're all kind of trusting each other when they say that, I think. So if one shows up, they're all showing up. And then they're probably going to prepare for the meeting as if the appeal will play out, is my guess.
I guess, just my opinion, I don't know about the rest of them, but I'd like to force their hand. This has dragged on way too long. So whatever the right plan is with Attorney Wyckoff, to draw a line in the sand and force this to come to some closure. All we're doing now is every party is adding up the lawyer's fees, and they're the only one that's going to make out from this thing.
Yeah, there's an awful lot of resources being spent on this, and I tend to agree with Tom on I don't know if the best way to start that process is to ask Attorney Wagner to join us at the beginning of the next meeting, so we can actually understand what we can and can't do. But I don't know. That seemed like a good starting point to get counsel on like how we can you know, better shepherd a solution or a resolution here, if we can at all. Not sure that we can, but
Yeah, well, Attorney Wagner's, he reaches out to me each month, and he's always ready to join if we need him to, regardless of whether or not any other attorneys are going to be present. So we can certainly ask him to join during the next meeting.
That'd be a
Regardless of where things
that'd be
go.
a great idea.
Okay. So do I have a motion to table the administrative appeals, all administrative appeals related to 18 Fernwood Road and 28 Whitetail Lane?
so moved.
Any further discussion on this?
None
So
for
all
me.
those, okay. So all those in favor of continuing the table, David Murch, yes.
Greg Dean, yes.
I'm going to say reluctantly yes, and not next month. I will not vote yes again.
Fred Miller, yes.
Pete Lockwood, yes.
Okay, very good. So those items will remain tabled until our next meeting in July. Next up is public hearing for Eric Coleman Furnish. So I would, this was for a setback reduction related to 90 Tenny Hill Road, map lot block 1815, zone rural. This was tabled in anticipation of a survey being provided for this meeting. It's my understanding the survey is not available. However, I would like to make a motion to untable this item for further discussion. Can I get a second on that?
Seconded.
Any further discussion before we vote? All those in favor of untabling this item? David Murch, yes.
Greg Dean, yes.
I'm going to say yes.
Fred Miller, yes.
Pete Lockwood, yes.
Okay, Pete, you're new to this board. You were not a member of the board at the time we did this review. at the last meeting. However, you did attend the site walk, correct, as a member of the public?
Yes, I did.
Okay, and you were in attendance at the last meeting as a member of the public, is that correct?
That's correct.
And what have you done in advance of this meeting that you are a member to better prepare yourself for this case?
I have looked over the meetings that you suggested, which was May 28th. I have read over the information and that I have been provided with. Have some of the packages, including this one. So I was able to look at the sketch that was developed, but no survey, as you have stated, has been provided.
Okay, so do you feel that you're in a position to be a part of this case as a ZBA board member?
Yes, I do. Having done the site walk, I'm very familiar with what we're looking at.
Okay, very good. During, as you would have noticed, I'm sorry, did you say you reviewed the video portion of this?
Yes,
Okay.
earlier.
Okay, so during that time, we did review the shoreline, or not the shoreline, we reviewed the land use ordinance, Article 6, Section D for reductions for minimum setbacks. During that time, each board member, we went through the list of requirements for that, and we made it all the way through item number 8. Of those items, during the time, all board members were in unanimous decision that items 1 to 7 were satisfied. I do believe that we may have had, we did have as well some reasonable conditions. Or are you in agreement that all items 1 to 7 have been satisfied, or did you have a difference of opinion with any of those in addition to the reasonable condition?
I was in agreement with all of those, David. I did not have a different opinion.
Okay, very good. So, is there a representative here tonight for Eric Coleman Furnish?
Yes, I am Danelle Maloney, present for Eric Coleman Furnish. Thank you.
Yeah, so Danelle, can you speak to the update that you have for us?
Yes, we thought there was a survey available. We do not when we went to go find it, we do not have a survey available. We are pursuing that survey, and companies are booking out 3 to 4 months to complete them. So, we're pursuing the request of the board. We'd like to pursue the request of the board and work towards what you've asked for, but it's just timing. For that reason, we're requesting to table the issue. I understand after hearing the last discussion why this isn't it's something that we need to do with respect, and so we are requesting that it be tabled to 4 months to October in order for us to get the surveyor out there, complete the work, and present it to the board without having to come back and continually ask for the board to table the issue as we're still waiting for the survey to be completed.
So our next meeting would be October 25th. You feel that's sufficient time to get a survey completed and submitted?
We're working towards that goal, that deadline. We've been quoted October, and if the board is willing to go to November, I would request that, but I do not want to burden you or the timing. I'm looking to you for guidance in terms of what would be appropriate for that too. We're going to do our best to get them there as quickly as possible and get that done so that we can submit it. I understand. We don't want to waste your time taking it off and on every meeting now through October or November.
Other members of the board can certainly ask some questions now, but for my own comments, I mean, we could certainly consider tabling it until, say, November, which would be November 26th. And then if a survey is available prior to that, such that it could get on the October, meeting, that to me would seem to be fine. Just we can table it for, for no later than, and then meet on it sooner if that's potentially an option, but I'll put that out there to my fellow board members to discuss as well.
Dave, I'm okay with that. I mean, I think it's gives them the time. It's not that they're not trying to do it. They're just don't have anybody to come do it.
So, so Danelle, if we propose to table this, retable this until the meeting of November 26th at the latest, if I'm hearing you correctly, that would be sufficient to your needs.
I think that's generous and reasonable, and I appreciate that.
Okay. I should read too. There have been, the town of Raymond voted in ordinance changes a few weeks ago, and with those ordinance changes came an elimination of the setback reduction appeals that are in both land use ordinance and shoreline zoning. We did confirm though with our town attorney, and this is an email that we received from Sandy. It says, please be advised that Phil Saucier Esquire has confirmed that the board may proceed with the tabled setback reduction applications from May 31st, 2022 meeting. This is because one application has substantial review prior to tabling, and the second, while no substantial review was conducted at the time of tabling, the shoreline zoning amendment eliminating setback reduction applications will not be effective until approved by the DEP or 45 days from the passage of ordinance changes. So just in case there's any question, even though the setback reductions have been eliminated from our ordinances and are pending, at least for shoreland, that does not affect this currently, well, this application, which was tabled prior to those being passed. I'll mention too, and I'll need to the board, we did receive on June 28th, some questions and comments from Ray Richardson. This was an abutter who had some problems or technical issues with him being able to speak during public comment at the last month's Zoom meeting. This email from Sandy indicates that he's not able to be a part of Zoom tonight, but wanted to present these items for our information. I'd just like to bring this to fellow board members. Do you have any concerns or problems with discussing those items tonight that Ray has presented? I would like to consider them only in the sense that there were technical issues at that last meeting and he was not able to speak, even though we saw multiple times he attempted to do so, but couldn't because of technical issues. Does any member of the board have a problem or have any concerns with us going through those comments tonight?
I'm okay with it, Dave.
I'd appreciate going through them.
Yeah, no issue, Dave.
Greg, you good?
Yeah, that's fine. Yeah. Sorry. Yep.
Let's see. Here, I'm gonna bring these up. So this is from Raymond Richardson, 84 Tenny Hill Road, June 28, 2022, Zoning Board of Appeals, re Eric Coleman, 90 Tenny Hill. Dear board members, first and foremost, I'd like to apologize to the board for my language at the last Zoom meeting. I have only for questions and statements. How long is temporary? It is going on 2 years. Item number 2, Eric Coleman's attorney said the carport was not used as a garage, but that's what it was used for, to park and to store his white Mercedes-Benz last winter. It was parked until. And then number 3, his ATV was parked in unit number 2.
David, excuse me, that's not until it says unit 1.
Oh, thank you very much.
Took me a while to
Okay.
figure it out.
Okay, yeah, I appreciate that. So number 2, it says it was parked in unit 1. Thank you, Sandy. And then this makes more sense now. Number 3, his ATV was parked in unit 2. And then number 4, the previous owner, William Pandolfo, built the correct attached garage. It is close to 700 square feet. If Eric Coleman was not using the garage for growing marijuana for the businesses that he operates at 90 Tenny Hill, he would have more than enough storage. Enclosed are 3 pictures, Raymond Richardson. So, I don't know if the board has any comments with regards to that.
I guess this is Tom. I made the comment the last time that if it's next to the driveway, a car was going to find its way in there. So here's documented evidence of that. And I guess my question to Alex is, growing or selling marijuana didn't pass the ordinance, from what I understand, that was voted on last month or earlier this month, whenever it was. So I don't know if Alex has a comment.
Oh, I will say quick before Alex jumps in, for that item number 2, where he's the Mercedes, we do have reasonable condition that was to indicate that there was going to be no storage of a motor vehicle in there. So I do think that part at least has been addressed. So I'll just put that out there. Sorry, Alex.
So, yeah, you're right, Tom. That article did fail. However, what that really means for Raymond is we're not an opt-in town, so you can't have marijuana establishments and you can't have retail grows, retail storefronts, medical storefronts, processing facilities. There's a whole list of things. What the town can't regulate is caregivers. If they're going to be a caregiver out of their own home, for example, they can still do some of that. And the town can't really stop them from that as long as they're doing it, legally in the state size, as a licensed caregiver. So I'm not sure if he's a licensed caregiver. He may be. That's something I can look into and see if he's got that license with the state. I'm not sure if I can get that information, but I will try. And if that's the case, then it's possible that that may be fine. But it's also possible that he might be growing and selling for recreational purposes, or he may be processing. I don't know. I'm not aware of anything as far as the town's concerned, any permit for any type of activity or business that's taking place there.
We're looking at a setback reduction, not specific. It can't be for a garage because there's already a garage on the property, and we've covered that. So I'm not sure if the use of the attached garage really plays into anything that we need to make a decision on. It's kind of the way I'm looking at it. I could be wrong.
Can I have a comment here?
Of course.
Yeah. Seems like Tom's raised some valid points. I just think that there might be enforcement issues more than they are zoning board issues. Is that a fair way of looking at it, Alex, in terms of if the garage is, I don't know who's enforcing that, but like there's no permit for the use, and or if the vehicles that we've conditionally excluded are put into the structures that the setback is for. I mean, both of those seem like enforcement issues. Is that correct?
Yeah, I wouldn't disagree with that.
Also, I'm not sure that the photos, I just want to point out my interpretation of the photos because I don't think the public sees them in the Zoom necessarily. I I don't see, I see vehicles near the structures. I don't see them in the structure. And that's kind of suggestive that they might be used for carports, as carports, as Tom has said, but I don't think it's necessarily evidence that they are being used or have been used for carports.
Right, I would agree. Just to explain to the public, though, there is a picture of the pre-existing garage, two-door pre-existing garage is a picture of one of the temporary carports with a UTV outside of it, and then appears to be a picture of the white car, but again, not necessarily, I just see it sitting in the driveway, so. So
I agree with Greg too. I mean, you can't tell, you know, that these cars are inside.
yeah. And the thing is, if in regards to what we're looking to, with regard for this appeal, we will be attaching a reasonable condition that will address item number 2 and item number 3 on this list about an ATV being parked as well as a car being parked in it. The only other issue, I guess, to talk about is how long is temporary. It's going on 2 years. Again, I don't know, is that specific to, you know, our board to look at? So it seems to be just either a question that needs to be looked into either by the town, but I don't know, is it necessarily something that we need to look into with regards to our ordinances and what we have to look at for a setback reduction.
Yeah, I think that sorry, David, just to clarify on that point, I think it may be in follow-up to a question that I had asked, because the structures were said to be temporary, and asked if there was some sort of explanation for what temporary meant, but I don't think it actually applies to anything that we're deciding on. I just was curious.
Right.
So. I did have one other question with respect to the survey, if now's an appropriate time to bring that up.
Please. Yep.
Yeah. Alex, could you just, I don't know if you know, and just you can say you don't know, it's pretty reasonable, but like, is the time frame that is being proposed seem consistent with kind of your understanding of the current market of getting surveys done?
Yeah, it is.
Okay.
And Janelle, given that we basically are allowed for some public comment here, did you have anything you wanted to state with regards to the comments that were provided to us tonight?
Yes, I mean, I'd like to put our position on the record since other opinions have been put on the record. You know, we're working with the town to work within their timeframes. We've been communicating with Alex all along, and so we're trying to be consistent and respectful of what those timeframes are as they relate to what it means to be temporary. So as far as the garage, you know, and the use for those structures, my client and I've discussed since the last meeting the restrictions that you put on. I think the pictures that were submitted are evidence that he is being compliant with the request, and not that you know, that not necessarily that he's not. He does need the storage for things other than the vehicles, and I've been very explicit that that is a restriction that the board has requested. So you know, we're trying to take the steps to get to the right place. You know, Mr. Richardson doesn't have access to my client's garage. He hasn't been there in years. He has no idea what's going on. You know, I'd like to reserve any comments regarding the marijuana, considering that this is a public forum, and I think that that's a separate issue that's not within the scope of what we're here to discuss. I'm happy to discuss those with Alex separately, and happy to work with the board on that if it comes up. You know, my client's always working to remain in compliance with any state or town regulations that may apply to him in any capacity. And, you know, I'm happy to answer those questions. I just don't think right now is the appropriate time to do it. One thing to note here, and I feel as though we have to say it, is that Mr. Richardson's concerns are not brought in good faith and are a form of harassment. He's been complaining to the town for years on various code matters. including a complaint regarding my client's treehouse that he built for his children. He complained regarding vehicles parked in the driveway in the open. You know, he's using the town's time and money to further his own agenda. And, you know, I have to mention that because of the nature of his complaints. So, you know, I'm happy to continue to answer further questions with regard to this, but we really would like to do what the board has asked and obtain the survey so that we can move forward with this.
Okay, thank you. Board, do you have any other questions?
I don't.
No. So do we have a motion to table this application until no later than November 26th meeting, so that a survey can be obtained and provided to the ZBA?
So moved.
Do we have a second?
I'll second it.
Do you have any further conversation on this? So all those in favor of tabling this application until November 26th at the latest, all in favor? David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Pete Lockwood, yes.
Okay, very good. So Janelle, you're all set. So to communicate that to Eric.
Thank you. Appreciate
Okay,
it.
very good. Thank you.
Have a good night.
You too. So our next item is a tabled public hearing for applicant Deborah Haas Wilson, location 184 Deep Code Road, map lot 061, 38, as well as 39 and 40. Zone is in LRR2. Request for a setback reduction. This was tabled at our last meeting. Can I get a motion to untable this item?
So moved.
Do I have a second?
I'll second.
Any further comments before we do this? Okay, all those in favor of untabling this application, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Pete Lockwood, yes.
Okay, very good. So this is. So this is for, again, a application for a setback reduction at 184 D Code Road. A site walk was held on Saturday, May 21st at 10 a.m. All board members were present. However, no one from the applicant was present to speak on this particular appeal. We have received the appeal. It's a little bit light on information. Is there a representative for this application here tonight?
Good evening, all. My name is Matt Wilson. I'm the son of Deborah Haas Wilson.
And Matthew, if you can sort of give us an idea of what's being requested here with regards to this appeal, that would be great.
Of course, on the property at 184 Deep Cove Road, there is a freestanding garage that we would like to move further away from the lake as it currently stands.
So you're looking to take the existing structure and relocate it?
That is correct.
And do you have, so the request is for a setback reduction. Do you have the actual setback reductions that are being requested?
I do not have, oops, go ahead.
Sorry, because what was provided to us, again, it was just simply an application which says a request for a setback reduction. We were provided with a boundary and topographical survey, which shows existing garage, and then it says proposed garage. I guess I do see here 15-foot setback from the right of way. But you don't do you have any other specifics that you're aware of other than the fact of relocating of the garage?
That's also that I have with, again, I was under the impression that the redrawn with potential new location was appropriate for the application, so I don't have any additional information than
Okay,
that.
no, that's fine. When we were there at the site walk, it was unclear to us as to whether or not an additional garage was being proposed, if something was going to be rebuilt. It wasn't clear to us specifically what was being requested.
Of course, I can, I mean, I'll elaborate a bit. I mean, this moment in time, nothing has been decided, but the goal, of course, is if we do decide that we want to, I guess, potentially build an office space over the garage, be able to increase the roof height to 25 feet from the initial 20 feet. So we're trying to move it further away from the water line with that potential goal in the future if we do decide to move forward with that. So it's moving the garage to potentially allow us the opportunity or option in the future to make that change.
Okay. Kind of open this up to my fellow board members. Do you have any questions for Matthew?
So I guess when we were there, Dave, we saw the 4 flags that were kind of laying down. And looking at this, the map that we have, the aerial map, it looks like that's the area that they were talking about moving this, the one that they have now to this new location. And a quick calculation, the old building is 85 feet 6 inches away from the water, and the new location would be approximately 91.6, because we're kind of guessing on where that's landing. So it looks like they're moving it 6 feet maybe. Does that sound correct?
Are you saying, Fred, that this looks like it's going to be closer to the water? Or
No, it's gonna be 96. They're moving it 6 feet away.
Yeah.
That's what, you know, from the measurements that we looked at that day.
Yep.
I have the existing garage at 85.6 from the water, the edge of the water, and I have what we, as near as we could tell without having anybody there, there was 4 flags laying there on the ground, spaced out at approximately the size that looked like, and that was 91.6. So that would mean that they'd be moving the garage 6 feet closer to the right of way, but 6 feet farther away from the water.
Yeah. And those are informal measurements as well.
Yeah, right, that's just approximate measurement.
Yep.
I'm still, sorry, Fred, I don't, did you get, yeah. Maybe this is just me, but I'm still unclear what exactly the setback request is. Is there, maybe you can point in reference to from what line on what property boundary and or what boundary you want the setback from and what you want the setback to be?
So we're attempting to move the garage as far away from the water as possible, and moving it closer to the right of way. So moving it to that, I believe that 15 foot of the right of way on the road. So we're trying to move it as close as possible to the road, so it's further away from the water.
Okay, so you want, so if I just to re-articulate this back, just so I can make sure I'm on the same page, you're requesting a reduction from your front setback to 15 feet.
Correct, of the right of way. So that's what we believe is the furthest we're gonna move it away from the water.
Right. Okay, but that's the only like you got front, back, and both sides. The only thing you're requesting is the reduction of the front setback from, I believe it's 30 feet, but whatever you want, 15 feet.
Correct.
Okay, great. Sorry, I needed to clarify.
Thank you for the question.
David, this is Tom. I have a question or two.
Of course.
Looking at the boundary survey that we were supplied, where the old garage was and then proposed new garage, neither one of them is over 100 feet from the water. Is that correct?
Right.
Okay, and we are not allowed to modify anything and that's less than 100 feet from the water. So I think this discussion should end. So, but go ahead.
I had the same question, Dave. It looked to be like we weren't going to be able to meet with, if the relocation, I didn't know whether they would be grandfathered or not, but it seems to me they would not be able to meet the 100, at least 100 foot from the shoreline.
Yeah,
And is that why Alex sent it to us in the first place?
Well, he's not asking for a reduction. He's not asking for a setback reduction from the water.
Nothing is 100 feet from the water. There is so little on that boundary survey that's 100 feet from the water. So I'm
Yeah,
telling,
that's up to, but it's not really up to us, is it? And that's,
we're in the shoreland zone and we can't modify setbacks from the water.
we're not.
yeah, we're not, that's not being requested of us.
He's not asking for that.
I guess the
Alex?
question, I'm sorry, I guess the question I would ask is this a grandfather situation where the current condition is okay because it was before this requirement? If they relocate it, now it's no longer grandfathered?
And I think Alex is the one to answer that.
So you'd want to look at the non-conforming structure section, and this would be relocation of a legal non-conforming structure. You can rebuild a non-conforming structure, and you can do that as long as you don't make it any more non-conforming, and you relocate to the greatest practical extent. So what he's trying to do here is relocate this structure to the greatest practical extent and then some, essentially.
Listening. If I'm distracted, if somebody else wants to say something, I'm trying to find it in our ordinances here. So if I look a little bit distracted, I'm just.
So the goal of this is to move the one that's already there, correct? And then it maybe at some point look at putting a second story onto it?
Correct, and to increase the roof height 25 feet by moving it to the farthest non-conforming position away.
So we're just gonna move that same building. You're not tearing that one down and building a new one, correct?
So Alex, I'm trying to go through the ordinances here as best I can. It sounds like from the ZBA's perspective, we don't need to worry about, we just need to worry about the request for the front setback. Is that correct? Does the rest sort of fall into play when it
Yep.
comes to just the town or town's other ordinances that you would enforce?
Yeah, because on a lot where you can't meet the 100-foot setback, you can only go so far back. And what we need to determine is how far back is practical. In this case, he would be taking it a step further and saying, instead of being, 60 feet back, we want to go 65 feet back. But in order to do that, we need a reduction from the front. No, they're not just doing that to get it further away from the water. They're doing it because it benefits them because they can go higher. Because if you look at that, the proposed plan, and which is fine, by the way, I don't say that in a bad way. That's why the state changed the rules to be like this, to incentivize people to move their structures further back. So that green line on the proposed plan is the 75-foot mark. At the 75-foot mark, the max height allowed changes from 20 to 25. So if they can get their structure beyond that line, they can add an extra 5 feet to the roof, to the structure height. And it gets the structure further from the water, which is what everyone wants. So that's why the rules are, they used to just be, you could, go 35 feet tall anywhere. it just depended on how much volume you had. And so they got rid of volume and changed it to the stepped approach with max heights.
So yeah, I'm in the shoreline ordinances and I'm under section 12, nonconformance, section C, nonconforming structures, and I go down to item 3, relocation, and then it kind of starts in non-conforming structure may be relocated within the boundaries of the parcel in which the structure is located. And then there's a whole bunch of code enforcement, state law and such, but I'm not seeing any reference here to zoning board of appeals in regards to that aspect of it when it comes to essentially relocation. So I'm thinking, and then based, I think on what I'm hearing Alex says, we really only need to focus on this request for the 15-foot setback reduction.
Yeah, if you go to, if you're using the PDF on the website, it would be page 8, which is number 4, reconstruction or replacement.
Okay.
Any non-conforming structure which is located less than required setback from the normal high water line of a water body, which is what this one is, tributary stream or upland edge of a wetland, and which is removed or damaged or destroyed regardless of the cause by more than 50% of the market value of the structure before such damage and destruction or removal may be reconstructed or replaced, provided that a permit is obtained within 18 months. Eventually it gets down here, provided that such reconstruction or replacement is in compliance with the water setback requirement to the greatest practical extent as determined by the code enforcement officer. And it goes on to say, you can't increase the nonconformity. Then it's just kind of typical stuff from there.
So which makes me have to ask the question is do we have to look at a setback reduction in terms of nonconformity? Is that sort of one, can that fit into that category, or is a setback reduction sort of separate in this case from a nonconformity?
So the structure already exists within the setback. So the way I view it is as long as they're not going any closer than where it currently is, they're fine with that. And did Jeff Kalinich reviewed this one, right, Sandy? And did he have any comments other than it was not a reduction for the water?
I believe that was what he said.
Yeah, so typically their
Take a
standard
quick look.
response. The standard response will be, the setback reduction is not a request for a reduction to the setback from the water, so we don't really, care, essentially.
Yeah, pretty much.
Yeah, and I do have that. Setback reduction requests are for
Yep.
setbacks from roads only. While these requests are for parcels in the shoreline zone, the mandatory Shoreline Zoning Act does not establish mandatory minimums for road setbacks. The department has no comment on these requests. So that was the official response. So Tom, do you have concerns about this, further concerns, or are you okay with moving forward with this?
No, I think Alex cleared it up.
Okay.
Now, when we did do the site walk, we didn't really find, but I think one of the iron pins to actually judge the location, but are we back to asking for a survey or not?
I don't know.
I hate to go down that path, but
Right. Well,
or we could put the whole burden on Alex.
They actually have 2 surveys for this lot, so they're not going to care. I can tell you that. They've had
Okay.
2 done.
All right, there we go.
The drawing that we have it says it's a boundary and topographic survey, but it's not actually stamped or signed. So I don't know why that is, but maybe someone just did a quick markup, and since it's a proposed plan, they didn't stamp anything. But the first one isn't either. So, I mean, that's something they can get you guys for sure if you wanted to do that.
All right. You're the one that needs it, Alex, right? For a building plan or building permits.
Yeah, we would require it for any replacement of a non-conforming structure. They need to either have the structure pinned by the surveyor, or they need to provide documentation with, an after the fact certification from the surveyor stating that it is, where it was supposed to be.
David, that answers my questions. I'm ready to vote when you guys are.
Okay. I'm going to go ahead then, and we will open this up to public comments. Is there anybody here tonight that would like to speak in opposition? Is there anybody here tonight that would like to speak in favor of this appeal? And is there anyone here tonight that would like to speak just from a neutral perspective on this appeal? So we'll go ahead and close out public comments. Then we'll just start going through a review of our ordinances and see where that takes us. So if I look at, let's see here, our shoreline zoning ordinances. I had it up here, but then I went other areas. So section 16, administration, section G, appeals. Then we have, go from there, we have further section F. And the Board of Appeals may grant reductions from the minimum setback requirements set forth in section 15A of these provisions according to all of the following criteria. So we've got 8 criteria that we need to go through. We'll go through each one of them, take an informal vote as we go through whether or not this appeal satisfies these requirements, and then we'll do a final vote as to whether or not we can grant the appeal. So item 1, setback reduction appeals are only available to reduce the minimum requirements for setbacks of structures from lot boundary lines. Setback reduction appeals shall not be used and are not available for bodies of water as provided in these provisions. So we're looking at a setback here from a right of way, request for 15-foot setback from right of way. I believe this item to be satisfied, but does anybody have any comments or concerns on this one? So I'll go ahead and take a little vote here. All those in favor of this item being satisfied, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Pete Lockwood, yes.
And number 2, setback reduction appeals may only be granted and are only available for lots with a residential dwelling as the principal structure. At the site walk, there was a residential dwelling, at least appeared to be so, on as the principal structure. Do we have any comments on this on the board? So all those in favor of this item being satisfied, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Pete Lockwood, yes.
Number 3, the Board of Appeals may grant a setback reduction appeal if the board finds that granting the setback reduction will not result in unreasonable interference with the privacy interests of abutting landowners. Again, at the site walk, didn't see any privacy issues. There were members of the public there. Nobody voiced any concerns there, and certainly nobody from the public was here tonight to speak about privacy issues. So all those in favor of this particular item being satisfied, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Pete Lockwood, yes.
Granting a setback reduction, the Board of Appeals may attach reasonable conditions which it may deem necessary to serve the purposes of these provisions. We will likely be coming back to this one. Number 5, a setback reduction appeal shall not be granted to enable construction or renovation that will create additional dwelling units. So it was discussed that an office space may be placed up above there. I have a feeling we should probably attach a reasonable condition to this that states specifically that a additional dwelling unit cannot be created at any point with regards to this structure. Thoughts on that?
I agree with that. Also, about a bathroom there.
I think bathrooms, I think we talked about this, bathroom isn't considered.
I think the kitchen's the
Yeah, I think it's the
kind
kitchen.
of the real indicator. I also
Correct.
think, David, if I can add to that, I think it might be particularly important also because the setback changes to the setbacks in general, whereas, you know, it's kind of statutory now that it can't be an additional dwelling, and if they go away, it may not be clear. So,
Correct. Yep, that's a good point, Greg. So all those in favor of this item being met with a reasonable condition being attached that no dwelling unit can be placed as part of this structure. All in favor, David Murch, yes.
Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Pete Lockwood, yes.
Setback number 6, a setback reduction appeal shall not be granted to enable construction or renovation that will result in more than one garage on the lot that is being subject of the appeal. So we've confirmed that this is simply a relocation of an existing garage. So I don't see that any additional garage is going to be here. So all those in favor of this item being met, David Murch, yes.
Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Pete Lockwood, yes.
Number 7, no setback reduction appeal may be granted that will result in impervious surface lot coverage of greater than 15% based on this boundary and topographical survey. I'm thinking this will be met. So all those in favor of this item being met, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Pete Lockwood, yes.
Number 8, setback reduction appeals may only be granted the minimum extent necessary to accomplish the purpose of the appeal. Setbacks may not be reduced by setback reduction appeal to less than the following absolute minimum setbacks: front yard 15 feet, side yard 10 feet, rear yard 15 feet. We are looking at a setback reduction from a right of way, which I should probably get confirmation from Alex that I'm assuming, Alex, that is the same thing as a front yard. Is that, let's see, Alex has gone black on me. Does anybody have any concerns that we're looking at a front yard reduction here? Or that we're not? Yeah, okay. Just the right of way just kind of threw me off a little bit. So all those in favor of this part of the appeal of the ordinance being satisfied, David Murch, yes, it's satisfied.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Pete Lockwood, yes.
Okay. So
And
those
David, you are correct. That's where the lot gets its road frontage, the right of way. So yes.
okay, wonderful. Thank you. Thank you. So having done a review, all 8 items have passed. In addition, we have added a reasonable condition that no dwelling unit shall be created as part of this setback reduction.
Dave,
Yes.
didn't we pass 4?
What's that?
Did we go back past 4?
Did we? Oh, we did. Thank you very much. In granting, thank you. In granting a setback reduction, the Board of Appeals, no, we didn't, Fred. In granting a setback reduction, the Board of Appeals may attach reasonable conditions which it deems necessary to serve the
Okay, so
purpose.
they passed them. Okay.
Yep, so that reasonable condition ties into number 5, that additional dwelling units will not be created as part of this appeal, granting of this appeal. So, seeing that all items have passed, I would like to make a motion that we approve this appeal for a 15-foot setback, front setback reduction with the reasonable condition added that additional dwelling unit will not be created. Do I have a second on that?
Seconded.
Do we have any further discussion? No. So all those in favor of granting this appeal, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Pete Lockwood, yes.
Okay, so Matthew, the appeal has been granted. So,
Thank you all.
yep, thank you for your time tonight. So moving on to new business, public hearing for applicant Fred Hollister, location 16 Wild Acres Road, map lot 069008, zone LRR2. Description, a setback variance, a side setback from 20 feet to 3 feet 4 inches to allow construction of a 12-foot by 8-foot storage shed. Fred, I see that you're with us tonight. If you want to go ahead and just give us an idea of what you're looking to accomplish, and we'll ask a few follow-up questions to go with that.
Sure. Can folks hear me?
Yes, we can hear you. Yes, I can.
Not sure. I tried to turn on my video and all of a sudden I disappeared off the screen.
We can hear you.
Okay. I've been looking to have a storage structure on the property, and I know those who visited saw the location, and that seemed to be the best place to put something on the property that disrupted as minimally as possible. And the neighbor to my east, Bob Dillenbach, I think wrote a note expressing his support or fact that he was fine with it. That's the side of the property that would be impacted the most because we share that side, and there's a fence there. The shed is the dimensions it is just so that cars can still move around the circle, so as it doesn't block traffic trying to get out the driveway. As I think I indicated on the day of the visit, there really were just kind of two places to do it. The other was closer to the water and closer to the Dillenbach's house. Also would be running over the line, the septic line running up to the leach field under the driveway. So this seemed like the most satisfactory place to put it, all things considered. And so I'm seeking the variance on the side of the lot.
Okay. Board members, do you have any questions for our applicant?
So the only setback we're looking for is from the fence to the new shed, right? And that's a 3-foot 4-inch setback.
Yeah, that would be the sort of the back wall of the shed. And I put it that close as, again, just trying to ensure that the driveway is navigable on both sides of the circle and still being able to fit a structure in there, because I don't really have any other storage structure. A lot of things just remain under a deck outside all winter, and was hoping to ameliorate that situation.
It looks like you're gonna put an 8x12.
8 by 12, yep.
we have any other questions?
Quick question.
Yeah.
So this is for a variance. Is that, at least that's what I'm interpreting this as, is that correct?
Right. Yeah.
Okay. Okay.
You're gonna Alex, I have to ask you a question. I thought I could pull it up and I can't. I'm in shoreline zoning ordinances. I know if we were looking at setback reductions, there was an absolute minimum setback we could allow under the setback reductions. I'm trying to find something similar. When it's a setback variance in shoreland, but am I missing that?
So I know the land use ordinance had some pretty specific reduction limits, but in the shoreland zoning provisions, I think that only exists in the setback reduction. If you look at, so it's number 2, variance appeals, which is page 59 in the online PDF. I don't believe there is a specific max, you guys can do.
Yep. Okay, so essentially if they wanted 1 foot, that could be an option.
Yeah.
Okay.
Quick follow-up question with respect to the variance. Well, actually, let's just go ahead. Well, actually, sorry. Did we decide? I know there's been talks of changing the strictness. I know there's 3 different flavors of the state allows in terms of hardship. And maybe I'm getting ahead of ourselves. I can wait, David, if you want. I'm just curious if we're looking at the right version that's applicable now based off from any recent ordinance changes.
Yeah, if you're looking at the variance appeal section, which is G2, that is what would currently be in play for this.
Okay, and there's no changes to no
Not
recent
to that
changes.
section. Nope.
Okay. All right, I'm mistaken then.
Nope, you're good. It would be the next one down that is removed, and we added in one for variances for new single-family homes. So that wouldn't apply here.
Okay. Thanks.
Yep.
I am looking.
Yeah, I don't know if it needs to be said, but no plumbing, no electricity, just a shed structure.
And this is Tom Hennessy. I wasn't present at the site walk. I was out of town. I take it this is the typical shed that has no foundation. It's just a pre-made foundation or
Correct.
structure that slides in place.
Yeah, I was going to use an outfit over in New Gloucester that manufactures sheds, and then they come in and install, put a bed down, I guess a gravel bed, and then sonotubes or I'm not sure what, and then shed sits on that.
Yep. Okay.
I'm trying to find it in my emails and I can't, but we did receive Sandy forwarded us an email from one of your
Sent
abutters.
to you on June 7th.
I've got it here if you want me to read it. David.
Oh yeah, please, Greg, if you read it.
Yeah, this is an email from Robert Dillenbach, which is an abutter to the east. And it says, Sandy, thank you for explaining the necessary response to my part to allow Fred Hollister to build a shed next to my property. My property is directly abut to Fred Hollister's property. I have no objection to the variance or location of the shed next to my property. Please submit this email to the Board of Appeals so that Fred Hollister can build his shed. Thank you.
Sandy, did we get anything from the DEP on this one? Yes or no?
Let me take a quick look. I don't remember.
Okay, okay.
Oh, it was part, never mind. I'm confused.
Okay. If you find it, let me know.
Sure.
I will state also for the record that a site walk was held on this property on Saturday, June 18th, 2022 at 9 a.m. In attendance for the board were David Murch, Craig Dean, Fred Miller, and Pete Lockwood. Tom Hennessy was unavailable. Our applicant, Fred Hollister, was there as well. So I will go ahead and if we've got, board has no further questions, at least for Fred, I'm going to go ahead and open this up to public comments. Do we have anybody here tonight from the public who would like to speak in favor of this appeal?
David, I don't see anything from DEP,
Okay,
but it's
Thank
not
you.
from the water.
okay. Do we have anybody in the public that would like to speak in opposition to this appeal? Finally, do we have anybody in the public that would like to speak from a position of being neutral to this appeal? So we'll go ahead and close out public comments. So we are looking at this as a setback variance, and again, we're in the shoreline zone. So this is, we're looking at specifically section 16 administration, section G appeals, item number 2, variance appeals. Variances may be granted only under the following conditions. Variances may be granted only from dimensional requirements, including but not limited to lot width, structure height, percent of lot coverage, and setback requirements. We are looking at setback requirements. Variances shall not be granted for establishment of any uses otherwise prohibited by these ordinance provisions. And then section C, it says the board shall not grant a variance unless it finds that. So number 1, the proposed structure or use would meet the provisions of section 15. After for the specific provision which was created the nonconformity and which relief is sought. And then finally, what we're looking at is number 2, the strict application of the terms of these ordinance provisions would result, in undue hardship. The undue hardship shall mean, and then we'll go through, there's 4 items of undue hardship that need to be met. And our applicant has provided information with regards to how there is undue hardship. The board needs to review each one and come up with a final conclusion. In terms of granting the setback variance, all 4 conditions of hardship will need to be met. So the first one, the land in question cannot yield a reasonable return unless a variance is granted. In our application, Fred has indicated much of the existing circular driveway cannot accommodate a shed very well, given the 1, narrowness of the circular drive, number 2, the location of the leaching field, and number 3, the proximity of the lakefront at the south end. So I'll just kind of open it up to my fellow board members in regards to this. Again, we're looking at hardship, all 4 of which must be met.
So this is the G2C2I, right? Just so I understand.
Yes, thank you.
And the reasonable return is my understanding that this is very broad in the sense that any particular use can be considered a reasonable return. Just to clarify, Alex, so it's like bird watching, camping, stuff like that. Would that be considered reasonable return? Or
Yes, yeah. Day use of a vacant lot is still a reasonable return according to the state.
okay. So if that's what the ordinance says, unfortunately, I don't see how we can improve that.
Yeah, I agree. This is a replacement of a shed. Applicant has indicated there's an alternate placement of the shed which could work. yeah, I don't see how there is an undue hardship here. As agreed, it's been stated that a lake property on the water can yield a reasonable return just by simply going there to sit and look at the water. So for item number 1 for undue hardship here, all those in favor of number 1 being satisfied, David Murch, no, that's not, the undue hardship has not been satisfied.
Greg Dean, no.
Tom Hennessy, no.
Fred Mullen, no.
P. Lockwood, no.
Number 2, the need for the variance is due to the unique circumstances of the property and not to the general conditions of the neighborhood. And as stated in the applicant has indicated, as stated in number 1 above, the limited availability of the flat space in and around the present driveway is the challenge. This proposed siting of the shed takes all of the above into account and continues to allow for the driveway to be possible. So based on, again, the site walk of the property, driving through the neighborhood, having looked at, the land maps around it, I don't see that there is any sort of unique circumstances specific to this property. It seems, the surrounding properties seem quite similar. Any of the board members have some comments on this? Okay, well, I'm going to say for all those in favor of item number 2, the undue hardship having been met, David Murch, no, it has not been met.
Greg Dean, no.
Tom Hennessy, no.
Fred Mullen, no.
P. Lockwood, no.
And number 3, undue hardship, the granting of the variance will not alter the essential character of the locality. Applicant has indicated while a portion of the shed cited as proposed would necessitate this variance in consideration of the 7-foot setback from the property line within a butter, the structure would be barely visible from their property and as far back as possible from their house. Again, based on the site walk and provided pictures, in my opinion, this would not alter the essential character of the locality. If anybody else has anything they want to contribute to that. So all those in favor of number 3, undue hardship having been met, David Murch, yes, this has.
Greg Dean, yes. I'm sorry. Yeah.
Very good.
Tom Hennessy, yes.
Fred Mullen, yes.
P. Lockwood, yes.
And the final hardship, the hardship is not the result of the action taken by the appellant or a prior owner. This is correct. Sorry, the applicant has indicated this is correct. It's not just the want to have an enclosed storage space accessible by the driveway that allows for, I cannot read this.
Cars to continue to be.
Oh, thank you.
Types of
Yeah.
property.
And avoid present leaching fields, be far away from the abutter's dwelling and view, as well as shoreline of Sebago. Anybody want to talk to this one? I'm trying to decide how this is a hardship one. Does anybody want to talk us through this one?
I mean, one interpretation of it is that the shed doesn't fit there, and it's not his fault that it doesn't fit there. But the other interpretation is the size and location of the shed is up to him, and it is because of that action.
I know that the applicant has indicated that there is an alternate placement of this shed, so.
Yeah.
So I guess this, you could argue that the hardship is the result of the action taken by the appellant in determining that the placement of the shed is there as opposed to this alternate location.
Yeah, I always struggle with this one because that kind of feels like like that would nullify all. I haven't seen one that would not be of the result or an action taken by the applicant. Right, because if just merely applying is an action that creates the hardship, you're automatically disqualifying yourself. So I think I was kind of thinking that in my thought was, did he put, did the owner or the previous owner do something to the property that created, did they, put a leach field in, or did they move something, or did they, alter the property that creates the hardship? It's not clear to me that that's the case here. It just seems like the property doesn't fit the shed. I don't know.
Yeah. Any other thoughts on this, Tom?
This is Tom. Sorry, I didn't make the site walk, but if there is an alternate location, and I see by the diagram, there is like 3 or 4 buildings, and one is labeled carport. Is it possible as an alternative solution to just enlarge the carport and not have to request any setback variance?
The carport, because of the topography, the carport cannot be expanded any further. I would like to, because it's really tight if you're putting 2 cars underneath it. But I can't really go anywhere. And the alternative site is the one that I mentioned that would go over the leaching field, would be closer to the wall. I mean, I'd have to apply for a variance regardless, because each site would be within the 7 feet of the side of the lot. There is no place on the property. I mean, you could see the kind of the hill and whatnot. There's no other part of the property that it could be sited on except this circular driveway area. And, they're just the kind of the 2 open spaces. And my neighbor, Bob Dillenbach, has a shed on the other side of the fence, closer down to his house. And I just thought, he'd probably appreciate not looking at it as close to his house as the other site would be, again, going over the leaching field. So.
David, can I ask a question for Alex here?
Oh, of course.
On 4, just for clarification, Alex, could you give me an example of a hardship that is not the result of an action taken by the appellant or prior owner? We're having trouble interpreting like what the action is. Like, obviously applying is the action, is part of the action here.
Yeah. No, I don't think I could, to be honest. I could probably try and think on that one on the spot, though. No, I can't come up with a.
It seems to me that if you can't come up, we might be interpreting it a little bit incorrectly in terms of like, just merely wanting to put a shed somewhere being the action that disqualifies you. That's just my only point.
Well, I guess, you could argue that the hardship is that, I don't know where I'm going with this. The placement of the driveway. I have a hard time with this one. Any other thoughts before we take a informal vote on this one? Okay, number 4, has the hardship not the result of an action taken by the appellant. Has this hardship been met? Because I cannot come up with an actual reason as to why it hasn't been met. I'm going to have to say that it has been met. So I'm going to say yes, it has been met.
Greg Dean, yes.
I'm gonna say yes.
Fred Miller, yes.
P. Lockwood, yes.
Okay, so we've gone through the 4 items of hardship requirements, though, are that all 4 items of hardship must be met in order to grant the variance. Informally, we have determined that item number 1 and item number 2 of undue hardship have not been met. Item number 3 and item number 4 have been met. I will make a motion that I forget how these are supposed to work. We deny the appeal, given that only 2 of the 4 items of hardship have been met.
Seconded.
Any further discussion before we go through on this? Okay,
So-
all those in favor of denying this appeal, David Murch, yes.
Greg Dean, yes.
I'm gonna say yes.
Fred Miller, yes.
P. Lockwood, yes.
So unfortunately, we have to do a review based on our ordinances and the definitions of undue hardship. All 4 of those definitions of undue hardship have to be met in order to provide you with the setback variance. And unfortunately, the board has determined that only 2 of the 4 have been met, so we have to deny
Can
it.
you just explain to me the first 2? And I'm really confused about this hardship that, anyway, can you just explain the first 2?
We will be writing up specifically, why these have been denied, but the first one, the biggest one is number 1, where the land in question cannot yield a reasonable return unless the variance is granted. There are legal precedences that say any waterfront property can yield a reasonable return, even if it's just to simply place a park bench on the property to look out over the water. So
I thought this was about, I'm really confused.
yeah, well, we will write up, this decision will be written up and provided to you. So, but tonight we've gone through the ordinances and the board has unanimously concurred that undue hardship has not been met. Okay. So we'll go ahead and move on in our agenda. Alex, Code Enforcement Officer Communications.
Yeah, so David.
But
kind of
before
told
I
my-
sign off, when do I hear about this?
Sandy, when can he expect at the latest to receive something?
Well, you have to write up the decision
Yep.
and everybody's got to sign it. So
Typically, what's sort of our deadline for getting something provided? 30
you
days?
usually do yours in a couple of days. And then I just have to get all of you to sign. Greg.
Hey.
So if you're all available, I can always leave it for your signatures like I've done before in a folder on my desk if I'm not there. But we have a holiday weekend coming up. Well, we're closed on Mondays anyway, so I would say the longest should be within a week.
Okay. And what is my recourse from here?
You have 45 days, I believe, that you can go to Superior Court.
David, do you mind if I make one comment?
No, of course, Craig.
Yeah. Fred, you might want to, Alex might, in this time frame where you're waiting or you feel like you're waiting, Alex might be able to provide some additional, I don't know if that's appropriate or not, but Alex might be able to provide some additional context around these 4 things that we have to interpret. I think it's warranted. I understand your frustration. However, it is the ordinances and we don't have a lot of leeway, and in particular variances, which you've applied for, can be kind of surprising. So I think if you were to give Alex a call and schedule some time, Alex, I hate to volunteer you for this, but I think you might be able to help.
Yeah,
Would you
that's
be
no
willing
problem at
to,
all.
Alex?
Yeah, that's no problem at all. If you want to give Kirsten a call tomorrow morning, she can schedule you either for a phone call or office meeting or Zoom, whatever you want to do.
Okay. I'll do that. Thank you.
Yeah, no problem.
You all set, Fred?
Yeah, all set.
Okay. So Alex, Code Enforcement Officer Communications.
Yeah, so I was saying, David, you kind of stole my thunder with revealing the ordinances had all been amended, but I totally understand. It made sense in the moment. No, so yeah, everything that was proposed by the planning board went through. So we kind of see firsthand how that's going to go now for you guys. Had he submitted as a setback reduction, that would have gone differently. So, you know, that's going to be, unfortunately, just the way it goes from now on. There's going to be some educating that'll have to be done by, you know, myself and my office, just letting people know if you don't meet these criteria, it's not worth spending the money to apply. You know, we did actually make some changes to the fee schedule as well. That's going into effect July 1st. It doesn't really change a whole lot on the ZBA side, but we are going to increase some of the noticing fees, and we're changing how we're doing the escrows a little bit. So I think it's just going to need, you know, we'll need to do some educating before people get to you guys, which, you know, that's going to be, that's pretty common. That's how most towns are doing things. You know, the setback reduction thing, like we talked about, is not normal. And that's, you know, just the way Raymond has been for the last, I think it's been 15 years or so that we've had it. So, yeah, so everything else passed. That'll clean the ordinance up. The ordinance amendments, just so you guys know, General Code has pretty much completed that. They're finishing that this week. That ordinance amendment will include the changes from this year as well. It's going to require a special town meeting or a town meeting vote in order to adopt the codified ordinance and get that on the website. I'm hoping that we can try and do that for the fall sometime, so we don't have to wait till next June. Once that's done, all the ordinances will be on a new online platform, and will be all updated land use and shoreline zoning. So we're hopefully 2 to 3 months away from that being done, finally. So that's all I've got.
Nice.
And Alex, just to what you said about the fee schedule, the only thing that's going to be different for the Board of Appeals is that we've always had a provision to charge an escrow fee, but it was never being done. So we're going to start charging an escrow fee.
And it was ridiculously high, so we
Right,
lowered
so
it
we
a little
lowered
bit.
it.
It was like $1,500 or something, right?
Yeah, what we bring it down to 5, I think.
Yeah, 500. So, you know, that I think will also deter people. I mean, to go to you guys now is going to cost, what's the total now to go to the ZBA? It's going to be quite a bit, almost $1,000 all said and done. Well, you 75 application fee, 500 escrow, and then I think 2 something for noticing.
Three
So-
for publishing.
300 for the 2 notices. And then
Yeah.
however, you know, $8 each for the abutter notices, and that varies from parcel to parcel.
Yeah. So, I mean, it's almost $1,000.
Right.
That's, you know, and the escrow, they'll probably get quite a bit of that back because we're not doing a whole lot of reviews by attorneys and professionals. So
Right,
lot of
but
that
it will
will get refunded.
it'll also offset if the publishing is more than we
Yeah.
have been billing for.
Yeah.
Because that's always a moving target as well.
So I think once we tighten that up, it should slow you guys down a little bit, actually. You'll see less appeals coming in, which is I think what the goal was to get you guys in line with what the statute says and what the zoning board of appeals should be doing. So I think we're just about there.
Sounds good. And I will mention too, if anybody on the board has questions about undue hardship and such, Sandy has provided to us, and at least I've got a PDF copy of, it's called Manual for Local Land Use Appeals Boards, a Legal Perspective, and it came through to me as just the title 2000 Appeals Board Manual, but it is a document that we can review and refer to in terms of what undue
Well,
hardship
that
is.
whole book, David, is about 6 or 7 inches thick.
Yeah, I've got the.
Why I'm not giving you printed copies
yeah.
of stuff.
No, I wouldn't want that, but can you ensure that Fred and Pete at least have a copy of it if they haven't already? Just a
I
PDF.
Thought that I sent it to Fred. I may not have, and I didn't send it to Pete yet. So yes, I will.
Awesome. Thank you so much.
Put it on my list for tomorrow.
And
This is the sorry, David, this is, just to
No.
clarify, this is the MMA document that Sandy circulated last, like, a year ago? or-
Yes, Greg.
Oh, okay, yeah.
yeah, it's got some good stuff that we can legally refer to in our decisions. So, and just, I know this is Alex's turn, but just Sandy, just a reminder, we've got board elections next for the next agenda. Okay. So anything else before we wrap up? Anyone? Okay. I'll make a motion to adjourn. Do I have a second?
Seconded,
All in favor, David Merch, yes.
Greg Dean, yes.
I'm going to say yes.
Miller, yes.
Pete Lockwood, yes.
Thank you for your time tonight, Pete. Good job, first time.
Yeah, thanks, Pete. Welcome.
Thank you.
All right.
Thank you, guys.
everyone.